Hey everyone, Brian Fouts here.
And Jake Fouts.
And we're here again with Kevin Day. Appreciate you being here.
Oh, absolutely. Yeah. Thank you for having me on.
And today we're going to be talking about lawsuit protection in the security section of EVG and how it applies to whether or not you're a W-2 employee, whether you're a business owner. Lawsuits can happen, out of the blue. It doesn't matter if you're a W-2 employee or a business owner. For the average American, especially, it's going to be 1 out of 4 is going to actually have a lawsuit at some point in their lifetime. And as you have successes and obviously have wealth, that increases. I think you had mentioned it was 1 out of 2. If you're a business owner, is going to have some sort of a lawsuit or litigation.
They will have a devastating one sometime in their lifetime.
Yeah. And so the way to protect against that, obviously, is to have the asset protection in place prior to the litigation happening, because once it starts to happen, you're out of luck. You can't really go back in time. So it's about being prepared, and that's what EVG is all about, is about having that knowledge to be ready. So this is the intro video, where we're going to go through what that means, asset protection for litigation, and then we're going to have some additional videos on whether or not you're a W-2 employee or a business owner, and then also we're going to go into another video about trusts and how they apply to asset protection. Mm-hmm. And then one question I want to ask you about, we're always talking about the United States because that's where we're located, but this also applies to anyone who is going to be doing business in the U.S. and they're out of country as well.
Yes, we have a lot of clients that are from Canada, Mexico, and Europe that know that the United States has 95% of the world's lawsuits, and they're more aware of it than Americans. We get jaded and we think it's normal that you're supposed to sue people. And so they are actually much more alert of setting up structures, not just to run the business, but to protect it. There's certain special constraints, let's say with Canadians, if we're setting up a foreign trust, they have T3 filings where the IRS equivalent filing is a 3520. So our firm is familiar with dealing with clients that are foreign nationals that are doing business here. We also do inbound trusts where people are actually going to immigrate here, and there's certain estate planning that they would want to do prior to coming in.
Great. Okay. So otherwise, for the overview of asset protection, whether W-2 or a business owner.
Mm-hmm. From an overview point of view, we really want to go to Lawsuit Protection 101. And I think it's an important introduction before we get into the several segments, for lawsuit protection for W-2 employees and asset protection for business owners, is that you get this concept of how our legal system works. One, it all has to do with technical ownership. And who is the technical ownership? Who is on the pink slip? Who is the shareholder? And so we all know there's certain industries like contractors, developers, architects, certain type of architects, certain types of physicians. They are in really high liability businesses, and little ideas about how to do lawsuit protection are passed down in certain industries. Everybody needs to know these things. But we all have known people that have done it by the seat of their pants. I'm a construction company, I have cranes, I've got 20-year-olds driving trucks, I've got people up on ladders. My best friend that has a gold thumb on businesses says, hey, do you want to invest $100,000 in my new business? It's passive investment, there's no liability there. Here's my $100,000. Put it in my sister's name because she doesn't have any tenants. She doesn't have any employees. She doesn't have product or services that somebody might sue me on. It's actually a good idea. If I get sued, he wrote that share for the $100,000 out to my sister's name, not me. I'm lawsuit protected. The problem is my sister in my example that is a low lawsuit profile person, no employees, no tenants, no business, no services. She gets the freak car accident. She has the freak divorce. And actually there's plenty of cases where judges have even said, oh yeah, I see what you did and everything, but you took a significant legal step under the law and put it in your sister's ownership. That means it's susceptible to her creditors. And if it's truly worth protecting, it has value, there's tax consequences of gifting back and forth to people. Even if I did it at a very small value, but then it grows, then she's using her gift exemption to get it to me instead of what she wants to use for her own children, her own estate planning. The other thing is, if you're willing to put money of any real significance in somebody else's name, it's not just that you trust them. There's usually love involved. It's usually a relative, not always, but it's such a close affiliation that that's the last person on the planet that you want to be angry at, that their freak car accident took your retirement. So we've got plans that don't have to rely on third parties. And it's a trust. They're a closed universe. You don't have to rely on other people. You can be the beneficiary of it. You can set it up for yourself or your kids. And that's the last segment we'll talk about. There's many different trusts that can do the job on the lawsuit protection side. But it's powerful because it is an ultimate owner. So when a Carnation grandchild or a Kennedy grandchild has an $8 million or $10 million judgment against them, they're still living in nice homes and driving nice cars because of trusts like that. If the big dogs can use them and they're lawful, us little dogs can use them. So we just need to get you educated so you know how they're used. And some of you need them right now. Your estates are either large enough or the business you do has some inherent risk that it's worth doing, even though you might be a smaller estate. And the rest of you are going to be following EVG's advice and scholarship and education, and you're going to build your estate. So you need to listen to the next couple segments. So you go, oh, now it's been 2 years, I need that thing that they told me about. Ownership in our legal system, as you already saw, corporations and LLCs are separate legal people under the law. Whenever the law says people or persons, it means these business entities or humans. In our legal system, and hopefully all civilized legal systems, nobody owns us. So humans are an ultimate owner. Now, as we know, corporations, and I'm just going to use these two instead of all the business entities because these are the two that most people are using. Corporations and LLCs under the law are separate legal owner. You should be learning, I am not the company is not me. The law requires it, the IRS requires it. If I borrow money from my company, I'm the only owner, I have to have formality of an agreement and a minimum interest and everything. I had a gal that borrowed from her company, paid it back for 1.5 years religiously and wrote in the memo, payback of loan, had an audit, and the IRS says, where's your contract and what interest were you paying? And she said, I didn't have anything in writing or anything. And they said, we're going to deem that that was a distribution to you and you owe money and penalties for 2 years. And it was clearly not intentional, clearly evidence that it was a loan and she was repaying it. The law, that's just an example. You got to respect these things, and they are separate legal owners from you. So things that this owns, you don't own. You don't own this money. You don't own that real estate property. You own XYZ LLC. You own ABC Inc. So that is what you own. So these are separate legal owners, and that's why they're lawsuit proofed for that activity. Something blows up here, boiler blows up here, you have an insurance on $1 million, but there was 5 people in that family that died. You're outside of insurance limits. They are still capped by that LLC. They can't come through to get you unless they're able to pierce corporate veil. So this is an ultimate owner. These are not ultimate owners. What's another ultimate owner? An irrevocable trust. Not irrevocable. Irrevocable means it's changeable, so if you can change it, the court says, okay, you're going to get it back in your name and then you're going to give it to the creditor. But irrevocable trusts are an ultimate owner. Nobody owns it. So the original owner puts title and beneficial use into an irrevocable trust, and a trustee is the title holder. We're splitting the ownership in the legal sense. beneficiaries. So I was the title holder and I had the beneficial use. By putting it into the trust, I split it into a fiduciary holder, trustee, which can't be me, and the beneficiary. And our third segment will talk about whether you can or cannot, and what circumstances, what are the pros and cons. But as that is an ultimate owner, we have lawsuit protection. We have double aspects to that. One, we can tell the other side. I shouldn't be telling a client behind closed doors what I'd be embarrassed to tell a judge or an opposing counsel. And so what we want to do is have something that if they all know about it, and Brian mentioned, the only thing that would unravel things is a thing called fraudulent conveyance. If you had a current existing creditor that you've harmed and you set up lawsuit protection stuff, it can be unwind under this concept of fraudulent conveyance because you had a known creditor. But you set it up today and next week you by accident run somebody over in the crosswalk, this will hold even though everybody knows that you've set it up. But the added advantage in our legal system is attorneys are sloppy. They're not as perfect as they like to pretend to be on TV or elsewhere. And so if this is an ultimate owner, nobody owns that. It is the owner. When you're in deposition and they say, under penalty of perjury, what do you own? Do you list things you don't own? No, you do not. And so we are tactically able to narrow down what the wealth of your estate looks like. And so it's really important either to the W-2 owner that's building their estate or the business owner, and there's different configurations, to quadrant off whatever is valuable to you or maintains your lifestyle. We can legally get it out of your estate, but you can still have beneficial use of it, and it will hold up in court when it's done before your legal seas get crazy. You want to do it when your legal seas are calm. But it's tactically advantaged because our legal system, unfortunately, is about the lotto system. It's about blackmail. The biggest thing that I get feedback from my clients that have to go through litigation, they say, I understand what originated this anger and this lawsuit, but it doesn't seem to have anything to do with what's actually happening in the court case, because the court case is about blackmail. It's, you could lose everything. You better give me an extra $500,000. So if we can take valuable stuff off the radar screen completely, and legally completely, you have a closed universe. So the greed aspect of the opposing counsel and their client doesn't see half of the estate. That means they're willing to, sometimes lawsuits, I can give you examples, but lawsuits don't even start when we know that they should have, because we painted a picture that our client doesn't have enough wealth to go after. And so irrevocable trusts are a closed universe. You don't have to use a loved one or trusted person, and you can get real lawsuit protection. So that's the foundation of lawsuit protection, is you don't want to be the owner. That's the kernel.
But you want to control the owner almost.
Yes, you want control. Good point. Control has nothing to do with ownership. So we can make the client the manager down here, and the law is very clear. Being a manager down here and having the checkbook down here and making investment decisions or even getting paid a salary from this company is not tantamount to being a trustee. Right. So it will not invalidate or pierce the trust structure.
Okay. And I think it's imperative now that we kind of get to the nuts and bolts of the things that we're learning as you start to grow your wealth or build your businesses. And you and I were talking earlier, we all have goals and places we want to be, and as we reach those goals, I want to spend my time kind of enjoying what I've done, not spending all my time, energy, and efforts trying to protect what I've earned, what I've made, just because I didn't put one or two or three simple protection or liability protection, asset protection strategies in place. So I think that's the point that is really driven home for me as we kind of finish up this introductory video, and then we'll start to talk about how you guys can do this if you're a W-2 employee or if you're a business owner, and we'll kind of talk about some of the different kinds of trusts that we have coming up.
Excellent.
All right, sounds good. Appreciate it, Kevin, and we'll see you guys in the next video.